Good afternoon. We resume the session for rebuttals, and Mr. Foster has the floor.
Thank you, Mr. President. I hope you will excuse my presentation if it's kind of on the bullet point style as opposed to maybe logically organized. It's more organized in chronological order from what Mr. Orta said, as opposed to a great logical analysis. And so I would like to start with the first comment he made. He said that FEG didn't have sufficient capital and that its projections were overly optimistic. I think we need to remember that we're dealing here, FEG is RDC's investment vehicle under CAFTA. And therefore, we're not just looking at FEG. We're looking at FEG and RDC. And there certainly can be no credible assertion that RDC was insufficiently capitalized. Furthermore, in each one of the accounting certifications of the company of FEG's books, the accountants note that RDC has committed to provide the funds necessary for the operation of FEG. And so there is an explicit commitment as well as the legal point about FEG being the investment vehicle. And also I think we need to remember, insofar as thin capitalization is concerned, that FEG was only, RDC through FEG was only required to invest $10 million. It invested 20. That's hardly what you would call the result of thin capitalization. Insofar as so-called overly optimistic projections, please note the difference between RDC's projections concerning railroad revenues and the government's own projections. The government's projections, as contained in the documents put out to bid, were far more optimistic than RDC's projections about freight traffic. So the RDC actually had more conservative projections than the government itself. I think it's also important for us to remember that we're talking about a 50-year period of time. This is a 50-year concession for a reason. There's an explicit recognition by the government that in order to get people to make this kind of investment, all of which is up front, let's remember, there has to be a sufficient period of time for the business to be developed and for that investment to be recovered together with a profit. So the length of the concession, I think, is particularly important when you're considering these questions. We talked a little bit about the fact that RDC was initially focused more on the railroad than on the real estate. Well, of course they were. The railroad was the key to unlocking the value that was in the real estate. RDC had responsibilities to begin restoration of phases of the railroad and to operate trains on segments. If they didn't do that, they were in the position of being defaulted under Contract 402 and losing the real estate. Therefore, of necessity, they had to be more focused in the first instance on railroad activities, knowing full well that they had a 50-year period of time to unlock that value. Let's all just think of our own experiences. This is kind of like a golf course community. No one really believes that anyone builds a golf course to make money operating the golf course. They make the money selling the lots that surround the golf course. And those lots don't all sell out in 1 year. And they build the golf course first. And they concentrate on making sure that the golf course is operating well, so that people want to come and buy the lots that adjoin the golf course. So I think it was a perfectly natural thing. I would also point out that it was the honorable thing. They could have done a slipshod job, invested $10 million instead of $20 million, skimped on what they were doing with the railroad and spent all their time concentrating on that which was going to put the most money in their own pockets. But instead they concentrated on that aspect of the project that was most important to the country of Guatemala. So what I think Mr. Order is asking you to do is to fault RDC for taking the honorable course, not the quick course, the cheap course, or the self-profiting course. Professor Crawford also asked the question about if you, the tribunal, were to decide that the contract was lesivo, wouldn't that have considerable effect on a fair and equitable treatment claim? Well, I would ask you also to consider the possibility that you conclude that the contract was not lesivo, or that you conclude that the reasons advanced for lesividad, these legal defects, are not a proper ground, or that you conclude that the lesivo process itself did not afford due process, or you conclude that the process of lesivo, keeping it secret for many years, was done in bad faith. I would suggest to you that those conclusions would have an equal, if not greater, effect upon your consideration of fair and equitable treatment. Mr. Order told you that a public bid was not just a technicality. Well, it's interesting that a little bit later in his presentation, he admitted that in the original evaluation of the contract, the issue of the public bidding was not even mentioned. It was focused on presidential approval, not public bidding. So what we have here is a course of conduct by the respondent through 9 secret opinions of various lawyers, creating a catch-22 for themselves. They created a lack of public bidding problem for themselves as an excuse to declare lesivo, and once they create that problem, it, unlike the executive approval, can't be solved so easily. So if instead of creating these problems for themselves, when they identified the lack of executive approval of the contract as being a problem, if they had simply done that which was well within their own power, and that is secure the executive approval either from that president or any other president that came into office thereafter, then we wouldn't be faced with what we're faced with today. But the absurdity of this whole idea is demonstrated by Dr. Gramajo's testimony. When he was asked, why didn't you get another public bid, his answer was, we were afraid FVG wouldn't win it. It is incomprehensible that the real reason that they didn't get the public bid was because they were afraid FVG would win it. Under the conditions, you heard Dr. Gramajo and how determined he was in his campaign over many years and with 9 separate secret legal opinions to get this contract declared lesivo, and he's trying to tell you that the real reason they didn't want a public bid was they were afraid FVG wouldn't win it. Now, as to the issue of whether FVG or RDC had any idea that any of these contracts had contained illegalities, there is not a shred of evidence that FVG in any way knew that Contract 41 that was signed with Overseer Sarceño was in any way illegal. If they had ever thought that it was in any way illegal, would they have agreed to replace it with 143 and 158 if they had thought there was going to be a possible illegality in 143 and 158 as well? No one would do that. Why? It's undisputed that 41 was executed, and we had several opinions from the overseer at the time who negotiated saying there wasn't a thing wrong with that contract. Why would anyone agree to renegotiate a contract that everybody said had nothing wrong with it if they thought they were going to renegotiate it with an illegal contract? It makes absolutely no sense. And furthermore, isn't FVG entitled to rely on the fact that FEGUA's own legal department opined that Contract 143 was in effect and that FEGUA was accepting canon payments under that contract? Surely they can't come in here today and tell you that FVG knew the contract was illegal when their own legal department was saying that it was in effect and they were receiving canon payments under it. Mr. Orta posits what I would describe as the ridiculous assertion that we can rely on letter authorizations to use the equipment prior to Contract 143, but we are not entitled to have reasonable reliance on the contracts themselves. That also makes absolutely no sense. Mr. Orta, on numerous occasions and in slides, cites these 9 separate legal opinions that they secured, in secret, of course. Can't we rely upon the fact they never showed any of them to us? If they thought that we already knew that Contracts 143 and 158 were illegal, what advantage would there have been to keeping those opinions secret? Why wouldn't they have just given them to us? And furthermore, on the issue of good faith, if they had honestly wanted to resolve any problems that there were in connection with that contract, why wouldn't they have come to us and said, here is a legal opinion that we just got from so-and-so, or the Attorney General, or the attorneys for the Ministry of Communications, and they point out these problems in the contract. Why don't we get together and solve these problems? But none of that was ever done. And indeed, on this issue of good faith, even after Lesivo was declared, it was 6 months before they ever told us what the technical difficulties were with the contracts. Now, if there was any desire whatsoever to negotiate in good faith, to resolve the difficulties with these contracts, wouldn't the appropriate course of action have been to come to us and say, here are the problems. What can we do working together to solve them? Mr. Orta also tells you that the reason all these issues were in negotiation between the parties was because the claimant wanted all the issues to be negotiated at the same time. That's nonsense. The president created the high-level commission. At the same time he was creating the high-level commission, if you remember, Dr. Gramajo wrote him the letter asking him to declare the contract Lesivo in early January of 2006. You have the letter before you. The meeting with the president was on March the 9th, if my memory serves me correctly. He appointed the high-level railroad commission. Mr. Orta tells you, oh, the president was trying to solve these problems by appointing the high-level railroad commission. Well, what the president didn't do was to say, by the way, since January the 6th, I've been considering a request from this guy who's standing right over here at this meeting that we're having today. I've been considering a request from him to declare your contract Lesivo for a couple of months now. So why don't you sit down and talk about that when you're talking in your high-level railroad commission? Indeed, the absence of telling anybody about the Lesivo process while the high-level railroad commission was meeting cuts against them, not for them. If they had been negotiating in good faith, all of these things would have been out on the table. And FVG would have had the opportunity to say, wait just a minute. Those contracts are not Lesivo. You say they're Lesivo for X reason, but that's not right. You say they're Lesivo for Y reason, but that's not right. You say they're Lesivo for Z reason, let's fix it. None of that was done. The idea that the president would create a commission and appoint someone to run it and not even tell that person that for 2 months he's been considering the possibility of declaring this contract lesivo, the idea that that is proceeding in good faith toward the concessionaire is ridiculous. And look at the issues that Mr. Order would have you believe we brought to the table. Do you really honestly believe that we brought to the table the issue of changing the contract to eliminate the payments to the trust fund? We brought to the table getting paid under the trust fund. They're the ones who want to eliminate the requirement for payments to the trust fund. Do you honestly believe that we brought to the table an idea that we would eliminate the requirement of FEGUA to remove squatters? Of course not. We brought to the table the absolute obligation of FEGUA to remove squatters and their total and complete abdication of that responsibility. They're the ones who wanted to remove it from the contract. And in this regard, I'd like to direct you to where are my documents I had? C44. I'd like to direct you to C44, which I had right here. Here it is. Thank you, Nick. I want to read you something from C44. This is the proposal, which we call the take it or leave it proposal. They don't like those words, but I want to read you something from this document. On page RDC 002428, they say, in line with the privatization process, FEGUA called private companies to take part in a public bidding process to receive in onerous usufruct the repair, maintenance, use, and exploitation of the railway equipment owned by FEGUA. Now, they are reciting in this document drafted by them that there was a public bidding process for the equipment contract. As a result of said process, Ferrovias was awarded the onerous usufruct contract involving railroad equipment as documented by public deed number 143. They're reciting in this document that Contract 143 was awarded by public bid. I submit to you, gentlemen, that the reason this document says that is because that's the way they had decided to fix the problem. If they got Ferrovias to agree to all the other demands in this document, they were going to fix the public bidding process by just declaring that it had happened. Now, there are only two possibilities: that they didn't read what they wrote, or that that's what they meant, and that's what they were going to do. I don't believe you will be able to conclude that they didn't mean what they wrote, or that they didn't read it. Now, then go on from that, if you will, please, to the next page in this document. And look what it is that they want us to sign that day. Remember, they gave it to us on the 24th, and lesivo is going to be declared tomorrow. So their protestations that there was going to be time for any significant negotiations simply ring hollow. We had one day. That was it. And at the top of this, they're talking about renegotiating Contract 42. To restructure the National Railway Network Restoration Plan, surrender railway sections yet to be restored in which other investors may be interested, surrendering real property not destined to railway use, receiving railway sections that are currently free of squatters. That's all Contract 402. The next thing they deal with, not Contract 143. This is 402. The first thing they talk about renegotiating is Contract 402. Then they talk about renegotiating Contract 820. When they talk about modificating fees for railway and different from railway activities, and FEGUA not being bound to further evictions. And that's all. None of this has anything to do with the railroad equipment. And then finally they get down to 143 and they want to modify the trust. That's 820 also, I'm sorry. Modifying the payment trust regarding the actual amount that FEGUA has to contribute to the trust. They finally get down at the very bottom of the page to contract 402. Modifications to the contract in order involving railway equipment in order to rectify the terms which are deemed to cause lesion, and they don't tell us what they are. And then, of course, you get to the part they really were interested in, which is modifications to the amount of the fees. Now, they then tell us that we have to post a bond in order to guarantee, that's the next provision in here. We have to post a bond to guarantee that we will renegotiate these terms. And then, if you turn over to the last paragraph, general acceptance. The appearing parties in their corresponding acting capacities declare to expressly accept the contents of this instrument and are bound to fully comply the terms of this agreement. I submit to you that that is a take it or leave it offer. Let's also consider the circumstances that are involved in the meeting where the take it or leave it offer was presented. Mr. Sin was called early one morning, the day before the meeting was going to occur. He was told to show up at the meeting. He was not told what the meeting was going to be about, and he was not told that he was going to receive a settlement demand. And they fault Mr. Sin for going to the meeting and saying that he wasn't authorized to sign the document on the spot. Let's talk just a second about the personal liability of the president. The personal liability of the president, that reason is not included in any one of the 9 opinions that they got with regard to Lesivo. This is an after-the-fact invention of the respondents to try to justify what they did. It certainly was not a basis on which anyone ever said Lesivo needed to be declared. Now let's talk about the $50 million investment that the president demanded that we make. Gentlemen, you watched a video clip of the president making the demand. You heard, although not of good quality, an audio clip of the president making the same demand on the radio. We showed you no less than 8 newspaper articles, all of which have one variety or another of the same demand. But most important, these unreliable newspaper reports include the government's official newspaper. C-131 is the publication in the Diario de Centro America. That is the official publication. And it says, President Berger, Berger explained that the declaration of lesividad arises from the fact that the $50 million investment under said contract did not occur. Their official publication, they want you to believe that these were just some crazy reporters wandering around reporting things that had never been said. I would submit to you that the consistency of the reports of the newspapers themselves is excellent evidence of the fact that President Berger actually said it. But the idea that they want to disavow their own official publication is simply astounding. Now, Mr. Order told you he thought it was strange that all the letters from suppliers, customers, and others came right after Lesivo. If they hadn't come right after Lesivo, Mr. Order would have said, I certainly think it's strange if they were so worried about Lesivo that they wouldn't have written them right after Lesivo. He can't have it both ways. I would also point out that in Mr. Orta's timeline of the events involving Mr. Campoyo, he has inexplicably left out the meeting of March the 15th, 05, when Mr. Pinto explicitly threatened FVG. In fact, he said that FVG might be allowed to participate in their own deals. A very generous offer from Mr. Pinto. A small point, but Mr. Orta tried to say that Mr. McSwain was hired in 2006. In fact, he was hired in 2007, and his testimony explicitly says he was hired either in late 2006 or in early 2007. What we have here, gentlemen, is a situation, a problem created entirely by the government. They wanted to replace Contract 41 with contracts that had more favorable terms to them. They got FVG to enter into contracts 143 and 158 at an increased canon payment, and a canon payment that then went entirely to FEGUA rather than to the trust fund for the renovation of the railway. The contract specifically says that presidential approval was not required. And the testimony is that even if it was required, any president could have approved it. A new bidding system process was entirely within their control, and they say that they were worried that FVG wouldn't win. On the issue of collections, the arbitrators raised the issue of why aren't you out there collecting? Why isn't the government, who is the principal squatter, out there paying? That's the real issue. They can't come in here and defend and say our damages claim suffers from a lack of proof when they are the principal squatter who's not paying us. Mr. Orta talked about the Shufelt case. If you read it, you will find out that while the legislature said the contract was immediately brought to an end, the arbitrators specifically note that Mr. Shufelt, like FVG, was still in possession of the usufruct. And despite the fact that he was in continued possession, the arbitrators found that it had been a taking. On the issue of compensation, they would like you to believe that they've offered compensation. They say that we can get our money back, but in the Lesivo proceeding. But the only money we can get back is the canon fees we paid, not the compensation for the taking or for the lack of fair and equitable treatment. And that being the only compensation we can get, it is certainly not adequate. And there is no case which is ever held that a 5-year delay in making payment was prompt compensation under the terms of the treaty. They have clearly not provided prompt and adequate compensation, and that failure alone makes them liable for an indirect expropriation. On full protection and security, Mr. Orta says that we cited a few instances where we didn't think the government acted quickly enough. It's important to note that all of those figures that we gave you with regard to the governmental actions, both before we got the usufruct and after Lesivo, all of those instances are compiled not from our data, but from the government's own data that they provided in this arbitration. On the issue of damages, Mr. Orta says it is unrebutted that we had only losses. He repeated that 5 times. He was wrong the first time, the second time, the third time, the fourth time, and the 5th time. In fact, in 2004, as you know, if you take into account the money FEGUA was supposed to pay into the trust fund, we were profitable. So it is absolutely incorrect ever to say that this is a business that has never been profitable. In fact, if you look at the record of the EBITDA of the company was on a nice upward slope. It had actually attained positive EBITDA in 2004, and except for Hurricane Stan, would have been the same in 2005. Now, as to the award, when you conclude, as I think you will and certainly urge you to, when you conclude that RDC is entitled to an award on the merits, at that point, you will have concluded 3 times that RDC is right. Twice on jurisdictional points and once on the merits. Under those circumstances, I would submit to you that it is not only appropriate that the facts cry out for the award of cost and attorney's fees to RDC and FVG in connection with this proceeding. Thank you very much.
Thank you, Mr. Foster.